Please be seated. The sitting is open. The court meets today pursuant to Article 67 of the statute to deliver its advisory opinion on the request submitted by the General Assembly of the United Nations on the question of the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including Jerusalem. The questions on which the advisory opinion of the Court has been requested are set forth in Resolution 77/247, adopted by the United Nations General Assembly on December 30, 2022. By a letter dated 17 January 2023 and received by the Registry on January 19, 2023, the Secretary General of the United Nations officially communicated to the Court the decision taken by the General Assembly to submit these questions for an advisory opinion. Paragraph 18 of the resolution reads as follows, and I quote, "The General Assembly decides in accordance with Article 96 of the Charter of the United Nations to request the International Court of Justice pursuant to Article 65 of the Statute of the Court to render an advisory opinion on the following questions, considering the rules and principles of international law, including the Charter of the United Nations, international humanitarian law, international human rights law, relevant resolutions of the Security Council, the General Assembly, and the Human Rights Council, and the advisory opinion of the Court of July 9, 2004. A. What are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. B. How do the policies and practices of Israel referred to in paragraph 18A affect the legal status of the occupation, and what are the legal consequences that arise for all states and the United Nations from this status? End of quote. In accordance with usual practice, I shall not read out the introductory paragraphs of the opinion, which set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall accordingly begin reading the advisory opinion at paragraph 22. The full text of the opinion will, of course, be available at the close of the sitting. When seized with the request for the advisory opinion, the Court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the Court should, in the exercise of its discretion, decline to answer the request. The Court must satisfy itself, in accordance with the requirement of Article 96 of the Charter and Article 65 of its statute, that the question on which it's required to give its opinion is a legal question. In the present proceedings, the General Assembly put two questions to the Court. These questions relate first to the legal consequences arising from certain policies and practices of Israel as an occupying power in a situation of belligerent occupation since 1967. Secondly, they relate to how such policies and practices affect the legal status of the occupation in light of certain rules and principles of international law, and to the legal consequences which arise from this status. The Court considers that these questions are legal questions. In light of the above, the Court concludes that the request has been made in accordance with the provisions of the Charter and of the Statute of the Court, and therefore that it has jurisdiction to render the requested opinion. The fact that the Court has jurisdiction to give an advisory opinion does not mean that it is obliged to exercise it. However, only compelling reasons may lead the Court to refuse to give its opinion in response to a request falling within its jurisdiction. Some participants in the present proceedings have argued that there are compelling reasons for the Court to decline to give its opinion. As to the argument that the request relates to a dispute between two parties, one of which has not consented to the jurisdiction of the Court considers that the subject matter of the request is not only a bilateral matter between Israel and Palestine, but it is of particular interest and concern to the United Nations, and that giving the opinion requested does not have effect of circumventing the principle of consent to judicial settlement. As to the argument that the Court's opinion would not assist the General Assembly in the performance of its functions, the Court considers that it cannot substitute its own assessment of the need for such an opinion with that of the organ requesting it. As to the argument that the opinion of the Court would have an adverse effect on the negotiation framework, the Court considers that it is a matter of conjecture on which the Court should not speculate. As to the argument that the Court does not have sufficient information to enable it to give an advisory opinion, the Court considers that it has before it sufficient information to decide legal questions in a manner consistent with its judicial function. As to the argument that the questions are formulated in a biased manner, the Court does not consider that the General Assembly intended to restrict the Court's freedom to determine these issues. The Court will ascertain for itself whether Israel's policies and practices are in violation of the applicable rules and principles of international law before determining the legal consequences of any such violation. Having examined each of these arguments in turn, the Court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The Court then recalls the general context of the case before turning to the scope and meaning of the questions posed by the General Assembly. In this regard, the Court notes that the questions define the material, territorial, and temporal scope of the Court's inquiry. With regard to the material scope, questions A identifies three types of conduct, which question B describes as policies and practices of Israel. First, the ongoing violation by Israel of the right of the Palestinian people to self-determination. Second, Israel's prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem. Third, Israel's adoption of related discriminatory legislation and measures. The specific scope of each of these policies and practices is determined later, as the Court examined them in turn. Before turning to that examination, the Court limits itself to observing a feature common to all of them, namely that the terms of question A assume that these policies and practices are contrary to international law. By virtue of its judicial function, however, the Court must itself determine the lawfulness of the policies and practices identified by the General Assembly. In the present case, the Court considers that question A requires an assessment of the conformity with international law of those policies and practices of Israel identified in the request. The Court considers that in its request, the General Assembly has not sought from the Court a detailed factual determination of Israel's policies and practices. Therefore, in order to give an advisory opinion in this case, it's not necessary for the Court to make findings of fact with regard to specific incidents allegedly in violation of international law. The Court need only establish the main features of Israel's policies and practices, and on that basis, assess the conformity of these policies and practices with international law. In terms of its territorial scope, question A refers to, and I quote, the Palestinian territory occupied since 1967, unquote, which encompasses the West Bank, East Jerusalem, and the Gaza Strip. The Court notes that the various United Nations organs and bodies frequently make specific reference to the different parts of the occupied Palestinian territory. The Court also does so in the present advisory opinion as appropriate. However, the Court recalls that from a legal standpoint, the occupied Palestinian territory constitutes a single territorial unit, the unity, contiguity, and integrity of which is to be preserved and respected. Thus, all references in this opinion to the occupied Palestinian territory are references to a single territorial unit. The Court further observes that the question mentions measures pertaining to the holy city of Jerusalem. The ordinary meaning of this term is ambiguous and may be subject to multiple interpretations, but the context provides useful clarification in the present case. In light of this context, the Court is of view that the question posed by the General Assembly relating to the holy city of Jerusalem is confined to measures taken by Israel in East Jerusalem. In terms of its temporal scope, question A requests the Court to take account of measures adopted by Israel in the occupied Palestinian territory since 1967. However, the Court is not precluded from having regard to facts predating the occupation to the extent that this is necessary for the proper discharge of its judicial function. The Court notes that the request for an advisory opinion was adopted by the General Assembly on December 30, 2022, and asked the Court to address Israel's, I quote, ongoing, or I quote again, continuing policies and practices. Thus, the Court is of the view that the policies and practices contemplated by the request of the General Assembly do not include conduct by Israel in the Gaza Strip in response to the attack carried out against it by Hamas and other armed groups on October 7, 2023. Question B has two parts. The first part requests the Court to assess how the policies and practices of Israel identified by the General Assembly affect the legal status of the occupation. The Court observed that the use of the verb affect points to the possibility that such policies and practices may bring about changes to the legal status. However, the scope of the first part of the question depends upon the meaning of the expression legal status of the occupation in the overall context of question B. In the present context, the Court is of the view that the first part of question B calls on the Court to ascertain the manner in which Israel's policies and practices affect the legal status of the occupation and thereby the legality of the continued presence of Israel as an occupying power in the occupied Palestinian territory. The Court observed that both question A and the second part of question B call upon it to determine the legal consequences arising respectively from Israel's policies and practices and from its continued presence as an occupying power in the occupied Palestinian territory. If and to the extent that the court finds that any of Israel's policies and practices or its continued presence in the occupied Palestinian territory are contrary to international law, the court indicates that it will examine the legal consequences following from such findings for Israel, for other states, and for the United Nations. Having defined the scope and meaning of the questions posed by the General Assembly, the court must determine the applicable law. The applicability of certain rules of international law in the territory concerned depends on the status of that territory under international law. The court first seeks to ascertain the status of the occupied Palestinian territory under international law, and then determines which rules of international law are relevant for answering the questions posed to it by the General Assembly. The question posed by the General Assembly are premised on the assumption that the occupied Palestinian territory is occupied by Israel. In its 2004 advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory, the court set out the circumstances under which a state of occupation is established. The court observed that in the 1967 armed conflict, Israel occupied the territories situated between the Green Line and the former eastern boundary of Palestine under the British mandate, namely the West Bank and East Jerusalem. The court affirmed that subsequent events had not altered the status of the territories in question as occupied territories, nor Israel's status as occupying power. In its whole advisory opinion, the court did not express a view as to the legal status of the Gaza Strip, as the construction of the wall did not affect the Gaza Strip. The Gaza Strip is an integral part of the territory that was occupied by Israel in 1967. Following the 1967 armed conflict, Israel, as the occupying power, placed the Gaza Strip under its effective control. However, in 2004, Israel announced a disengagement plan. According to that plan, Israel was to withdraw its military presence from the Gaza Strip and from several areas in the northern part of the West Bank. By 2005, Israel had completed the withdrawal of its army and the removal of the settlements in the Gaza Strip. The court notes that for the purpose of determining whether a territory remains occupied under international law, the decisive criterion is not whether the occupying power retained its physical military presence in the territory at all times, but rather whether its authority has been established and can be exercised. Based on the information before the court, it considers that Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, including control of the land, sea and air borders, restrictions on the movement of people and goods, collection of import and export taxes, and military control over the buffer zone, despite the withdrawal of its military presence in 2005. This is even more so since October 7, 2023. In light of the above, the court is of the view that Israel's withdrawal from the Gaza Strip has not entirely released it of its obligations under the law of occupation. Israel's obligations have remained commensurate with the degree of its effective control over the Gaza Strip. The court then turned to the rules and principles that are relevant for answering the questions put to it. These include the prohibition of the acquisition of territory by threat or use of force, and the right of people to self-determination, which are enshrined in the Charter of the United Nations and also form part of customary international law. Further, international humanitarian law is of particular relevance. Israel's powers and duties in the occupied Palestinian territory are governed by the Geneva Convention relative to the protection of civilian persons in time of war of August 12, 1949, to which I shall refer as the Fourth Geneva Convention, which is applicable in the occupied Palestinian territory and by customary international law. Pursuant to Article 154 of the Fourth Geneva Convention, that convention is supplementary to the rules contained in sections 2 and 3 of the Hague Regulations respecting the laws and customs of war and on land annexed to that convention. As the Court has observed in its jurisprudence, the Hague Regulations have become part of customary international law, and they are thus binding on Israel. As regards international human rights law, the Court observed that Israel is party to several legal instruments containing human rights obligations, including the International Convention on the Elimination of All Forms of Racial Discrimination of 21 December 1965, to which I shall refer to as CERD, the International Covenant on Economic, Social and Cultural Rights of 16 December 1966, to which I shall refer to as the ICESCR, and the International Covenant on Civil and Political Rights of 19 December 1966, to which I refer to as ICCPR. The Court recalls that international human rights instruments are applicable in respects to acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories. The Court further recalls that the protection offered by human rights conventions does not cease in the case of armed conflict or of occupation. Some rights may be exclusively matters of international humanitarian law, others may be exclusively matters of human rights law, yet others may concern both these branches of international law. Referring to its Wall Advisor opinion, the Court observes that Israel remains bound by the ICCPR and the ICESCR in respect of its conduct with regard to the occupied Palestinian territory. In relation to CERD, the Court notes that the Convention contains no provision expressly restricting its territorial application. On the contrary, several of its provisions impose obligations on state parties that are applicable in territories under their jurisdiction or in relation to individuals within their jurisdiction. This indicates that CERD is also applicable to conduct of a state party which has effects beyond its territory. In the Court's view, Israel must comply with its obligations under CERD in circumstances in which it exercises its jurisdiction outside its territory. As several participants in the present proceedings expressed diverging views regarding the relevance of the accords signed in 1993 and 1995 by Israel and the Palestine Liberation Organization, also known as the Oslo Accords, the Court turns to those agreements. The parties to the Oslo Accord agreed to, and I quote, exercise their powers and responsibility pursuant to the accords with due regard to internationally accepted norms and principles of human rights and the rule of law, end of quote. The Court recalls that it considered in its Wall opinion that the legitimate rights of the Palestinian people recognized in the Oslo Accords includes the right to self-determination. The Court observed that in interpreting the Oslo Accords, it's necessary to take into account Article 47 of the Fourth Geneva Convention, which provides that the protected population shall not be deprived of the benefits of the Convention, and I quote, by any agreement concluded between the authorities of the occupied territories and the occupying power, end of quote. For all these reasons, the Court considers that these accords cannot be understood to detract from Israel's obligations under the pertinent rules of international law applicable in the occupied Palestinian territory. The Court then assesses the conformity of Israel's policies and practices in the occupied Palestinian territory as identified in question A with its obligations under international law. In particular, the Court's analysis examines in turn the question of the prolonged occupation, Israel's policy of settlement, the annexation of the Palestinian territory occupied since 1967, and its adoption of related legislation and measures that are allegedly discriminatory. The Court appraises whether, and if so, how Israel's policies and practices affect the right of the Palestinian people to self-determination after those other questions have been considered. With regard to the question of prolonged occupation, the Court notes that question A concerns in part the legal consequences arising from Israel's, again, quote-unquote, prolonged occupation of the occupied Palestinian territory. In this regard, the Court notes that Israel's occupation has lasted for more than 57 years. In order to answer this aspect of the question, the Court must turn to the relationship between Israel as the occupying power and the protected population of the occupied territory, which is governed by the law of occupation. By virtue of its status as an occupying power, a state assumes a set of powers and duties with respect to the territory over which it exercises effective control. In this context, the occupying power bears a duty to administer the territory for the benefit of the local population. The nature and scope of these powers and duties are always premised on the same assumption, that occupation is a temporary situation to respond to military necessity, and it cannot transfer title of sovereignty to the occupying power. The fact that an occupation is prolonged does not in itself change the legal status under international humanitarian law. Although premised on the temporary character of the occupation, the law of occupation does not set temporal limits that would, as such, alter the legal status of the occupation. Instead, the legality of the occupying power's presence in the occupied territory must be assessed in light of other rules. In particular, occupations consist of the exercise by a state of effective control in foreign territory. In order to be permissible, therefore, such exercise of effective control must at all times be consistent with the rules concerning the prohibition of the threat or use of force, including the prohibition of territorial acquisition resulting from the threat or use of force, as well as with the right of to self-determination. Therefore, the fact that an occupation is prolonged may have a bearing on the justification under international law of the occupying power's continued presence in the occupied territory. It is against this background that Israel's policies and practices, as well as its continuing presence in the occupied Palestinian territory, must be examined. The Court now turns to these policies and practices, beginning with Israel's settlement policy. Question A, posed by the General Assembly, inquires in part about the legal consequences arising from Israel's settlement policy. The Court considered in this regard that the distinction that is sometimes made between settlements and outposts is immaterial for the purpose of ascertaining whether the communities in question form part of Israel's settlement policy. What matters is whether they are established or maintained with Israel's support. The court further notes that between 1967 and 2005, Israel's settlement policy was carried out in the West Bank, East Jerusalem, and the Gaza Strip. Since the removal of Israel's settlement from the Gaza Strip in 2005, Israel's settlement policy has continued in the West Bank and East Jerusalem. The court therefore limits its analysis to Israel's ongoing settlement policy in the West Bank and East Jerusalem. At the same time, the court observes that Israel's settlement policy carried out in the Gaza Strip until 2005 was not substantially different from the policy that continues in the West Bank and East Jerusalem today. In its sworn advisory opinion, the court found that Israel's settlement policy was in breach of the 6th paragraph of Article 49 of the Fourth Geneva Convention, which provides that, I quote, "The occupying power shall not deport or transfer part of its own civilian population into the territory it occupies," end of quote. In the court's view, there is nothing in the terms or the context of the provision or in the object and purpose of the drafting history of the Fourth Geneva Convention to suggest that that provision prohibits only the forcible transfer of parts of the occupying power's civilian population into occupied territory. In the present case, there is extensive evidence of Israel's policy of providing incentives for the relocation of Israeli individuals and businesses into the West Bank, as well as for its industrial and agricultural development by settlers. There is also evidence that Israel regularly legalizes outposts that have been established in contravention of domestic Israeli legislation, and that Israel's construction of settlements is accompanied by special designed civilian infrastructure in the West Bank and East Jerusalem, which integrates the settlement into the territory of Israel. In light of the above, the court considers that the transfer by Israel of settlers to the West Bank and East Jerusalem, as well as Israel's maintenance of their presence, is contrary to Article 49 of the Fourth Geneva Convention. The court further notes that the expansion of Israel's settlement in the West Bank and East Jerusalem is based on the confiscation or requisitioning of large areas of land. Observing that, in the present case, the public property confiscated or requisitioned for the development of Israeli settlements benefits the civilian population of settlers to the detriment of the local Palestinian population, the court concludes that Israel's land policies are not in conformity with Articles 46, 52, and 55 of the Hague Regulations. The court next turned to the question of the exploitation of natural resources. It recorded that under the principle of customary international law contained in Article 55 of the Hague Regulations, the occupying power shall be regarded only as administrator and usufructuary of natural resources in the occupied territory, including but not limited to forest and agricultural estates, and it shall safeguard the capital of these resources. Therefore, the use by the occupying power of natural resources must not exceed what is necessary for the purposes of the occupation. In this connection, the court observed that the occupying power had the continuing duty to ensure that the local population has an adequate supply of foodstuffs, including water. Moreover, the use of natural resources in the occupied territory must be sustainable and it must avoid environmental harm. On the basis of the evidence before it, the court considers that Israel's use of the natural resources in the occupied Palestinian territory is inconsistent with its obligations under international law. By diverting a large share of the natural resources to its own population, including settlers, Israel is in breach of its obligation to act as an administrator or usufructuary. The court further considers that by severely restricting the access of Palestinian population to water that is available in the occupied Palestinian territory, Israel acts inconsistently with its obligation to ensure the availability of water in sufficient quantity and quality. In light of its analysis, the court also concludes that Israel's policy of exploitation of natural resources in the occupied Palestinian territory is inconsistent with its obligation to respect the Palestinian people's right to permanent sovereignty over natural resources. Turning next to the question of the extension of Israeli law to the occupied Palestinian territory, the court recalls that under Article 43 of the Hague Regulations, the occupying power must in principle respect the law in force in the occupied territory unless absolutely prevented from doing so. In principle, then, the law of occupation does not deprive the local populations, civilian institutions in the occupied territory of the regulatory authority that they may have. Rather, it invests the occupying power a set of regulatory power on an exceptional basis and on specific enumerated grounds. Based on the evidence before it, the court observed that Israel has expanded its sphere of regulation in the West Bank. It's note in particular that Israel has, to a large degree, substituted its military law for the local law in force in the occupied Palestinian territory at the beginning of the occupation in 1967. Moreover, regional and local councils of settlers have assumed de facto jurisdiction over the settlements in the West Bank. In East Jerusalem, domestic Israeli law has been applied since the beginning of the occupation in 1967, and Israel treats East Jerusalem as its own national territory, where Israeli law is applied in full and to the exclusion of any other domestic legal system, where Israeli law is applied in full and to the exclusion of any other domestic system. In the present case, the court is not convinced that the extension of Israel's law to the West Bank and East Jerusalem is justified under any of the grounds laid down in the second paragraph of Article 64 of the Fourth Geneva Convention. Furthermore, the comprehensive application of Israeli law in East Jerusalem, as well as its application in relation to settlers throughout the West Bank, cannot be deemed, quote-unquote, essential for any of the purposes enumerated in the second paragraph of Article 64 of the Fourth Geneva Convention. For these reasons, the court considers that Israel has exercised its regulatory authority as an occupying power in a manner that is inconsistent with the rule reflected in Article 43 of the Hague Regulations and Article 64 of the Fourth Geneva Convention. The court then turned to the effects of Israel's settlement policy on the departure of the Palestinian people. The court observed that the large-scale confiscation of land and the deprivation of access to natural resources divest the local population of their basic means of subsistence, thus inducing their departure. Furthermore, a series of measures taken by Israeli military forces has exacerbated the pressure on the Palestinian population to leave parts of the occupied Palestinian territory against their will. The court recalls that under the first paragraph of Article 49 of the Fourth Geneva Convention, I quote, individual or mass forcible transfers, as well as deportations of protected persons from occupying territory to the territory of the occupying power or to that of any other country, occupied or not, are prohibited regardless of their motive. End of quote. In this regard, the court considered that transfer may be forcible and thus prohibited under Article 49, paragraph 1, not only when it is achieved through the use of physical force, but also when the people concerned have no choice but to leave. Further, the court notes that to be permissible, evacuations are conceived as a temporary measures to be reversed as soon as the imperative military reasons subside. By contrast, evacuations of a permanent or indefinite character breach the prohibition of forcible transfer and therefore are not covered by the exception set out in the second paragraph of Article 49. The court considers that Israel's policies and practices, including its forcible evictions, extensive house demolitions, and restrictions on residence and movement, often leave little choice to members of the Palestinian population living in Area C, but to leave their area of residence. The nature of Israel's acts, including the fact that Israel frequently confiscates land following the demolition of Palestinian property for reallocation to Israeli settlements, indicates that its measures are not temporary in character and therefore cannot be considered as permissible evacuations under the Fourth Geneva Convention. In the court's view, Israel's policies and practices are contrary to the prohibition of forcible transfer of the protected population under Article 49, paragraph 1 of the Fourth Geneva Convention. The court further notes that Israel's settlement policy has given rise to violence by settlers and security forces against Palestinians. Having examined the evidence before it, in light of the relevant provisions of international law, the court considered that the violence by settlers against Palestinians, Israel's failure to prevent or to punish it effectively, and its excessive use of force against Palestinians contribute to the creation and maintenance of a coercive environment against Palestinians. In the present case, on the basis of the evidence before it, the court is of the view that Israel's systematic failure to prevent or to punish attacks by settlers against the life or bodily integrity of Palestinians, as well as Israel's excessive use of force against Palestinians, is inconsistent with its obligations. In light of the above, the court reaffirms, as it did in its sworn advisory opinion, that the Israeli settlements in the West Bank and East Jerusalem and the regime associated with them have been established and are being maintained in violation of international law. The court notes, with grave concern, a report that Israel's settlement policy has been expanding since the court's sworn advisory opinion. In particular, in December 2022, Israel Parliament approved the establishment of an additional minister within the Ministry of Defense, vested with the governing powers in the West Bank, including land designations, planning, and coordination of demolitions, which would expedite the approval process for new settlements. Also, the size of existing Israeli settlements expanded from November 1, 2022 to October 31, 2023 at a significant rate, with approximately 24,300 housing units within existing Israeli settlements in the West Bank being advanced or approved, including approximately 9,670 in East Jerusalem. The court observed that the question posed by the General Assembly refers in part to the legal consequences arising out of Israel's alleged annexation of the occupied Palestinian territory. In order to respond to this aspect of the question, the court must first analyze the concept of annexation. Second, the court examines Israel's policies and practices with a view to determining whether they amount to annexation. Finally, the court discusses the lawfulness of Israel's policies and practices. With regard to the concept of annexation, in the present context, the court understands that to mean the forcible acquisition by the occupying power of the territory that it occupies, namely its integration into the territory of the occupying power. Annexation, then, presupposes the intent of the occupying power to exercise permanent control over the occupied territory. The court recalls in this regard that under the law of occupation, the control of the occupied territory by the occupying power must be temporary in character. Consequently, conduct by the occupying power that displays an intent to exercise permanent control over the occupied territory may indicate an act of annexation. The assertion by the occupying power of permanent control of the occupied territory may manifest itself in a variety of ways. In this connection, the court notes that a distinction between de jure and de facto annexation is occasionally made, although differing in terms of the means through which the annexation is carried out. Both types of annexation share the same objective: the assertion of permanent control over the occupied territory. Against this background, the court must examine whether, through its conduct, Israel establishes its permanent control over the occupied Palestinian territory in a manner that would amount to annexation. The court first examines Israel's policies and practices in relation to Jerusalem. It notes that Israel has applied its domestic law in East Jerusalem since its occupation in 1967. In 1980, Israel enacted domestic legislation in the form of a basic law proclaiming East Jerusalem as part of its capital. Israel has asserted that East Jerusalem is part of its territory, as evidenced by the notification of the Israeli government to the Secretary General of the United Nations, according to which, and I quote, "Jerusalem is not in any part occupied territory, is the sovereign capital of the State of Israel." End of quote. The absentee property law of 1950 has facilitated the confiscation of absentee property and its use for the expansion of Israeli settlements in and around the historical borders of the city. It's reported that approximately 230,000 persons live in 14 settlements established in East Jerusalem. The court considered that Israel's measures in East Jerusalem create an inhospitable environment for the Palestinian population. Because Israel treats East Jerusalem as its own territory, it regards Palestinians residing there as foreigners, and it requires that they hold a valid residence permit. Israeli law has also put in place a building permit scheme, the violation of which results in demolition through an expedited procedure as well as steep fines. According to the Secretary General of the United Nations, Israel's process of land ownership registration is pursued in areas of Israeli settlement expansion, which would increase Israeli control over additional territory in East Jerusalem. Turning to Israel's settlement policy in the West Bank, the court observed that pursuant to the basic law of 2018, the State of Israel, I quote, "views the development of Jewish settlement as a national value and shall act to encourage and promote its establishment and consolidation," end of quote. The displacement of the local population from the occupied territory, which sustains Israel's settlement policy, also advances the integration of the territory. Israeli policies and practices induce the departure of the Palestinian population from parts of the occupied Palestinian territory, notably from East Jerusalem and Area C in the West Bank. This in turn enables the further expansion of Israel's settlement policy and the ready integration of Palestinian territory into Israel. The court also recalls that Israel's practice of exploitation of the natural resources in the West Bank is inconsistent with the right of the Palestinian people to permanent sovereignty over natural resources. Israel's extension of its domestic law to the West Bank, notably to the settlements and over settlers, as well as its assumption of broader regularity powers by virtue of the prolonged character of the occupation, entrenches its control over the occupied territory. policies, practices, and other measures that are such as to bring the occupied territory into the occupying power's permanent control constitute acts of annexation. Having examined Israel's policies and practices, both in relation to East Jerusalem and to the West Bank, with a view to determining whether they amount to annexation, the Court comes to the conclusion that Israel's policies and practices, including the maintenance and expansion of settlements, the construction of associated infrastructure and the wall, the exploitation of natural resources, the proclamation of Jerusalem as Israel's capital, the comprehensive application of Israeli domestic law in East Jerusalem, and its extensive application in the West Bank, entrench Israel's control of the occupied Palestinian territory, notably of East Jerusalem and of Area C of the West Bank. These policies and practices are designed to maintain in place indefinitely, to remain in place indefinitely and to create irreversible effects on the ground. Consequently, the Court considers that these policies and practices amount to annexation of large parts of the occupied Palestinian territory. It is the view of the Court that to seek to acquire sovereignty over an occupied territory, as shown by the policies and practices adopted by Israel in East Jerusalem and the West Bank, is contrary to the prohibition of the use of force in international relations and its corollary principle of the non-acquisition of territory by force. The manner in which the annexation affects the legal status of the occupation and thereby the legality of the continued presence of Israel is discussed later in the advisory opinion. The Court then examined the question of discriminatory legislation and measures. Recalling the wording of question A, and the conclusion it reached with regard to the interpretation of the question, it noted that it must itself determine whether the legislation and measures identified by the request of the General Assembly are discriminatory. In this regard, the Court first considers that it has to limit its analysis to legislation and measures that are closely linked to the policies and practices discussed previously. Second, the question covers Israel's legislation and measures only to the extent that they apply in the occupied Palestinian territory. Third, the question is confined to the potentially discriminatory character of Israel's legislation and measures. Having thus defined the scope of question A, the Court turned to the concept of discrimination. It considers that common to all of the relevant provisions of international law is the concept of differential treatment between persons belonging to different groups. It observed in this connection that the existence of the Palestinian people is not at issue. Therefore, in the Court's view, differential treatment of Palestinians can give rise to discrimination. In order to answer question A, the Court first examines the effects that Israel's residence permit policy in East Jerusalem has on Palestinians in the occupied Palestinian territory. The Court then turned to the restrictions imposed by Israel on the movement of Palestinians in the occupied Palestinian territory. Finally, it examines Israel's practice of demolition of Palestinian properties in the West Bank and in East Jerusalem, both with regard to the practice of punitive demolition and demolitions for lack of a building permit. The Court notes that in that connection, that it's reported that almost 11,000 Palestinian structures have been demolished since 2009. The Court concludes from the evidence presented to it and on the basis of its analysis that a broad array of legislation adopted and measures taken by Israel in its capacity as an occupying power treat Palestinians differently on grounds specified by international law. The Court notes that this differentiation of treatment cannot be justified with reference to reasonable and objective criteria, nor to a legitimate public aim. Accordingly, the Court is of the view that the regime of comprehensive restrictions imposed by Israel on Palestinians in the occupied Palestinian territory constitutes systematic discrimination based on inter alia, race, religion, or ethnic origin in violation of Article 2, Paragraph 1 and 26 of the ICCPR, Article 2, Paragraph 2 of the ICESCR, and Article 2 of CERD. A number of participants have argued that Israel's policies and practices in the occupied Palestinian territory amount to segregation or apartheid in breach of Article 3 of CERD. Article 3 of CERD provides as follows, I quote, "States parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction." This provision refers to two particularly severe forms of racial discrimination, racial segregation, and apartheid. The court observed that Israel's legislation and measures imposed and serve to maintain a near complete separation in the West Bank and East Jerusalem between the settler and Palestinian communities. For this reason, the court considers that Israel's legislation and measures constitute a breach of Article 3 of CERD. Having found that Israel's settlement policy, its acts of annexation, and its related discriminatory legislation and measures are in breach of international law, the court turned to the aspect of question A that inquires as to the effects of Israel's policies and practices on the exercise of the Palestinian people's right to self-determination. The court has already affirmed in its sworn opinion the existence of the right of the Palestinian people to self-determination. In the present proceedings, the court first determines the scope of this right and then examines the effects, if any, that Israel's policies and practices have on its exercise. In light of its analysis, the court is of the view that the prolonged character of Israel's unlawful policies and practices aggravates their violation of the right of the Palestinian people to self-determination. As a consequence of Israel's policies and practices which span decades, the Palestinian people has been deprived of its right to self-determination over a long period, and further prolongation of these policies and practices undermines the exercise of this right in the future. For these reasons, the court is of the view that Israel's unlawful policies and practices are in breach of Israel's obligation to respect the right of the Palestinian people to self-determination. The manner in which these policies affect the legal status of the occupation and thereby the legality of the continued presence of Israel in the occupied territory is discussed later. I'll now read in English paragraph 285, which contains the operative clause of the opinion. For these reasons, the court, 1, unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, by 14 votes to 1, decides to comply with the request for an advisory opinion. In favor, President Salam, Judges Tomka, Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez Robledo, Cleveland, Oresco, Tladi. Against, Vice President Sebutinde. By 11 votes to 4, is of the opinion that the State of Israel's continued presence in the occupied territory is unlawful. In favor, President Salam, Judges Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez Robledo, Cleveland, Tladi. Against, Vice President Sebutinde, Judges Tomka, Abraham, Uresco. By 11 votes to 4, is of the opinion that the State of Israel is under an obligation to bring to an end its unlawful presence in the occupied Palestinian territory as rapidly as possible. In favor, President Salam, Judges Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde, Judges Tomka, Abraham, Uresco. By 14 votes to 1, is of the opinion that the State of Israel is under an obligation to cease immediately all new settlement activities and to evacuate all settlers from the occupied Palestinian territory. In favor, President Salam, Judges Tomka, Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Uresco, Tladi. Against, Vice President Sebutinde. By 14 votes to 1, is of the opinion that the State of Israel has the obligation to make reparation for the damage caused to all natural or legal persons concerned in the occupied Palestinian territory. In favor, President Salam, Judges Tomka, Abraham, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Uresco, Tladi. Against, Vice President Sebutinde. By 12 votes to 3, is of the opinion that all states are under an obligation not to recognize as legal the situation arising from the unlawful presence of the State of Israel in the occupied Palestinian territory and not to render aid or assistance in maintaining the situation created by the continued presence of the State of Israel in the occupied Palestinian territory. In favor, President Salam, Judges Tomka, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde, Judges Abraham, Uresco. By 12 votes to 3, is of the opinion that international organizations, including the United Nations, are under an obligation not to recognize as legal the situation arising from the unlawful presence of the State of Israel in the occupied Palestinian territory. In favor, President Salam, Judges Tomka, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde, Judges Abraham, Uresco. By 12 votes to 3, is of the opinion that the United Nations, and especially the General Assembly, which requested this opinion, and the Security Council should consider the precise modalities and further action required to bring to an end as rapidly as possible the unlawful presence of the State of Israel in the occupied Palestinian territory. In favor, President Salam, Judges Tomka, Yusuf, Shway, Bandari, Iwasawa, Nolte, Chargeworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde, Judges Abraham, Uresco. President Salam appends a declaration to the advisory opinion of the Court. Vice President Sebutinde appends a dissenting opinion to the advisory opinion of the Court. Judge Tomka appends a declaration to the advisory opinion of the Court. Judges Tomka, Abraham, and Uresco append a joint opinion to the advisory opinion of the Court. Judge Yusuf appends a separate opinion to the advisory opinion of the Court. Judge Shway appends a declaration to the advisory opinion of the Court. Judges Iwasawa and Nolte append separate opinions to the advisory opinion of the Court. Judges Nolte and Cleveland append a joint declaration to the advisory opinion of the Court. Judges Chargeworth and Brandt append declarations to the advisory opinion of the Court. Judges Gomez-Robledo and Cleveland append separate opinions to the advisory opinion of the Court. Judge Tladi appends a declaration to the advisory opinion of the Court. The text of the opinion is available from today in TypeScript. It will also be available almost immediately on the Court's internet site. The printed text will be available in the near future. As the Court has no other business before it, I declare the sitting closed.